Hello. It's good to see you. Thank you for coming by. No, you're right on time. You're totally fine. Have a seat. Have a seat. Um, did you have any trouble finding the office? Okay, great. I know when we left the house this morning, you said you'd never been here before, so I'm glad you didn't have trouble finding the place. Okay, so you're prepared to make an offer on the house, right? Okay, that's wonderful. That's wonderful. I think personally, out of all the houses that we've looked at, I think this is going to be a really good choice for you, and I've got my fingers crossed that it works out because I think this would be a wonderful fit for you and what you're looking for. As you know, we have a lot of paperwork that we need to go over, and I'm going to explain some things to you as we go through this. I have some things that I'm going to need you to help me complete, and there are some things here from the seller's agent that I was able to obtain after we left the house this morning from the showing. I have some information about the seller, and we will go over that. But I'll also need some information from you. First of all, did you bring your earnest money check? Oh, great. Thank you so much. I'm going to, with your permission, since the attorney's office is already closed for the day, I'm going to go drop this off first thing in the morning. Is that'd be okay? And you made it out to, let me see. Okay, that's right. Now you were doing $1,000 earnest money. Okay, that we'll put this on this form in just a minute. But for right now, I'd like to direct your attention to the forms that we will need to fill out in order to make the offer official. Okay, the earnest money check is part of that, and we will go over some other information as well. Okay, great. Let's take a look at these forms. Okay, now we have right here a real estate purchase form, and this one actually needs some information from you, if that's okay. First, your name, Jane Smith. Okay, and I have a cell phone number for you, but in your email you said that number was not right. So if you will give me the correct number, 555-3608. Okay, wonderful. And that's your cell phone number. Do you have a work number or any other number that would be good for like an alternative number in case I can't reach you here? Work. Okay. It's 555-0178. Okay, wonderful. Now, I do have here this information I got from the seller's agent. The seller's name. Oops, I got those mixed up. I'll fix that. This is just a template, and I will enter all this in our computer system. The seller is John Jones. I have his phone number. Now, the address of the property, I have that right here. 127 North Main Street. Is that right? Yeah, it's 127. And that's in Camden. Okay. Now, the description of the property, it is a colonial style home and it does have a garage. Okay. Now, your estimated purchase price. Okay, now your offer, you are going to offer $168,500. Okay, I'm going to leave that there for now. How much will be paid as earnest money? You gave me the $1,000 check. I'm going to put that in parentheses. And the balance due at closing, if they accept the offer, will be $167,500. And I do need from you, I need to know how your purchase is going to be financed. Okay, that's fine. I will put that Camden Savings and Loan. Oh, we do. Actually, I deal with them pretty often. Okay, when will the closing be held? Now, you said you weren't really sure and you were going to have to take a look at your calendar. Do you know when you would like to do the closing? And of course, the buyer could come back and want to do it differently. But this is just, this is ideal. This is what we're looking for. So you're looking at May 31st, 2017. Okay. At closing, the amount to be paid by the seller, we are asking that they cover the closing costs and the 1-year home warranty. And this is an estimate. And the total for the closing costs and the 1-year home warranty is $5,500. The property inspection, we don't know about that yet, so we're going to hang on to that. Additional terms and conditions. I know you are going to ask that they leave that island in the kitchen, because right now that is not listed as something that will stay in the house. Was there anything else? That's right. The 2 stainless steel garbage cans in the garage. And I'll tell you, some sellers are great about little stuff like this, and I consider these little things. Some sellers are great, and they're more than happy to do it. Some are not. Some almost seem offended when you ask them to leave anything. So we'll actually have to wait and see how that turns out. But really at this point, I just want you to focus on the big things, like the closing costs and the 1-year home warranty. The 1-year home warranty is $485, and the rest is and I just rounded it up to $500. We're estimating $5,000 for closing costs, so I just made it $5,500. Okay. Now, the agent that I spoke with did tell me that this May 31st date may be a problem. He's actually moving out of state, and his new place is not going to be ready until about the middle of June. So this may be a problem. He may come back with a later closing date. But we'll see. We'll see what he says. I know that he is very eager to sell the house, so he may be willing to work something out. Okay. Now I'm going to read over portions of this with you. This is the residential real estate purchase agreement. And then we're going to fill out some of this information on here. We have the date of the agreement. And these are the sellers, which is just one person. And then we have the real estate description. For the date, we'll go ahead and put today's date. Today is April 25th, 2017. Okay. Now, the sellers. We only have one seller, and that is John Jones. The one seller. Okay. Now we have section 1. Real estate description. The undersigned buyer is hereby offered to buy real estate in Camden County. Locally known as, and that address again is 127 North Main Street Camden. Okay. And following the legal description contained in the title document by which the seller received title to the property, subject to approval of buyer's attorney, or described as follows. We're going to leave that blank. With any improvements located thereon, easements of record and pertinent serving estates, and subject to the following: A. Any zoning and other ordinances. B. Any covenants of record. C. Any easements of record for public utilities, roads and highways. And D. And then you have a blank here where you consider liens, other easements, interests of others. Designated the real estate, provided buyers on possession are permitted to make the following use of the real estate. And this is going to be your primary residence. So we're going to put that right here. Primary residence. Okay. Alright, now we have a little checkbox here. If applicable, see Homeowners Association, Condominium Association, Common Interest Community Addendum. There are no homeowners fees or anything in that particular neighborhood, so we don't need to worry about that. Okay, section 2, purchase price. The purchase price shall be, and we are asking to pay $168,500. Okay, and then you write it out. I'm going to do that later. And the method of payment shall be as follows. That's going to be $1,000 earnest money and financing. I really wish they'd give us more room in these little blanks. With this offer to be deposited upon acceptance of this offer, then the trust account, I'm going to put the seller's name, John Jones. Okay. To be delivered to the sellers upon performance of seller's obligations and satisfaction of buyer's contingencies, if any, and the balance of the purchase price as designated below. New mortgage, check, conventional FHA or VA. It's just conventional. Okay. This purchase agreement is contingent upon the buyers obtaining a written commitment for a first real estate mortgage for blank %. Now, we don't actually have that yet, do we? We don't know the actual %. Okay, that's fine. Of the purchase price with interest on the promissory note secured thereby of not more than blank % amortized over a term of not less than blank years with a balloon due date of not less than blank years. Buyer agrees to pay no more than blank % for loan origination fees and points, and to pay in addition all other customary loan costs. Buyers agree upon acceptance of this offer to immediately make application for such mortgage with the commercial mortgage lender and to exercise good faith efforts to obtain a mortgage commitment as above provided. Upon receiving written loan commitment, supported by the lender's required appraisal, buyers shall release this contingency in writing. If buyers have not delivered a written financing contingency release containing the above items, or terms acceptable to buyers on or before, and then we'll give a date and time, either sellers or buyers may declare this purchase agreement null and void, and all payments made hereunder shall be returned. Buyers shall pay the balance of the purchase price at the time of the closing by combination of buyer's personal funds and the net mortgage proceeds. Okay. So like I said, we don't know right now about the percentage. Okay, we don't really have the specifics for that. Are you getting a 30-year loan, 30-year mortgage? Okay. Alright, that's fine. We can actually leave this blank right now. For section B, that's for cash buyers, which you're not, and other financing terms, which we are not going to need since you're using just a conventional loan. Okay, here's section D. If a mortgage assumption, installment contract assumption, or installment contract sale, see addendum. Okay, we don't have that. Possession. If buyers timely perform all obligations, possession for the real estate shall be delivered to buyers on, and that will be the date of closing, hopefully, if they will agree to it, which would be May 31st, 2017, with any adjustments of rent, taxes, insurance, interest, and other applicable matters to be made as of the date of transfer of possession. Closing of the transaction shall occur after approval of title and vacation of the premises by the sellers, in the condition ready for buyer's possession. Possession shall not be delivered to the buyers until completion of the closing, which shall mean delivery to the buyers of all title transfer documents and receipt of the purchase price funds then due from buyers. If by mutual agreement the parties select a different possession or closing date, they shall execute a separate agreement setting forth the terms thereof. So, we're hoping he'll go with the May 31st date, but like I said, he may want to push that out a little bit. I just want you to be aware of that. Real estate taxes. Sellers shall pay all real estate taxes which are due and payable and constitute a lien against the above described real estate and any unpaid real estate taxes for any prior years. Except for the tax proration hereinafter set forth, buyers shall pay all subsequent real estate taxes. Sellers shall also pay a prorated share of the real estate taxes for the fiscal year ending June 30th, 2017. Okay, let's add that. And payable in the fiscal year commencing July 1st, 2018. Based upon one of the following formulas. And we're going to go with this one here. Net taxes payable in the current fiscal year in which possession is given to buyers. Just going to go with that one. Okay, and then section 5 is special assessments, which we don't need. So I'm going to have you initial that. We don't have the seller's initials yet. But they will, once they review all this, they will initial that. Now we look at section 6 here. Fixtures. All property that integrally belongs to or is part of the real estate, whether attached or detached, such as light fixtures, shades, rods, blinds, automatic garage door openers, and transmitter units, all drapery rods and curtain rods, awnings, windows, storm doors, screens, plumbing fixtures, water heaters, water softeners, unless water softener is rental, automatic heating equipment, air conditioning equipment, wall-to-wall carpeting, mirrors attached to walls or doors, fireplace screen and grate, attached barbecue grills, weather vane, all built-in kitchen appliances, built-in items, and electrical service cable, outside television towers and antenna, fencing, gates, and landscaping shall be considered a part of real estate and also include the following. I don't know that we have anything additionally. No, I think this is blank. I don't think there were any items that were not included in that. So we're just going to leave that blank. Each of the above included items or fixtures that integrally belong to or are a part of the real estate. Okay, in the deed. Upon payment of the purchase price, sellers shall convey the real estate to buyers or their assignees by a blank deed, free and clear of all liens, restrictions, and encumbrances except as provided in 1A through 1D. Any general warranties of title shall extend only to the time of acceptance of this offer, with special warranties as to acts of sellers continuing up to time of delivery of the deeds. And Section 8, time is of the essence in this contract. Section 9, condition of the property. The property as of the date of this purchase agreement, including buildings, grounds, and all improvements, will be preserved by the sellers in its present condition until possession, ordinary wear and tear excepted. The sellers warrant that the heating, electrical, plumbing, and air conditioning systems, well, if applicable, which it's not here since you're on city water, and all included appliances will, whether subject to inspection set forth hereinafter or not, be in good working order and condition as of the date of delivery of possession. In determining whether or not the warranted systems are in good working condition, and for the purpose of inspecting the property as outlined in paragraph 9b(1) of this purchase agreement, working condition shall be defined as operating in a manner in which the item was designed to operate. And of course, we're going to look at that in more detail when we do the home inspection, which that will be coming up before the closing date. Okay, and in section B, the buyers must choose one of the following alternatives relative to the condition and quality of the property. And then we have to give a time and a date. The buyers may, at their sole expense, have the property inspected by a person or persons of their choice. And I want to go ahead and put something down here. I want to put by 12 p.m. Now we're asking to close on May 31st. Let's say, I'll give you till May 17th, 2017. That'll give you 2 weeks. What do you think that would be okay? Okay, I'm just checking. Okay, so you will have to home an inspection. I know with Camden Savings and Loan, they will require that. And that will give 2 weeks to process it. So I think that would be enough time. And so you can have a person of your choice, including but not limited to a qualified home inspector, contractors, engineers, or other such professionals to determine if there are major deficiencies in the following major components of the real estate: central heating system, central cooling system, plumbing system, well and well water, which does not apply to this house, electrical system, roof, walls, ceilings, floors, foundations, and basement. Sellers and buyers acknowledge the property may have imperfect cosmetic conditions that do not affect the working condition of the item and are not considered major deficiencies, including but not limited to broken seals in windows, minor tears, worn spots or discolorations of floor coverings, wallpaper or window treatments, nail holes, scratches, dents, scrapes or chips in ceilings, walls, floors, and or surface cracks in driveways or patios. Failure to meet present construction standards and code requirements is not considered a deficiency in the property unless it is new construction or unless that failure produces a condition which creates an unreasonable danger or risk to the property or to its occupants. By the same date, buyers must notify the sellers in writing of any major deficiencies for which they are requesting remedies. So if there's anything big going on, they have to let you know by that May 17th date. The notification must be accompanied by a copy of a written inspection report from a qualified inspector identifying the deficiencies. Sellers shall, within 5 calendar days after receipt of buyer's notification, notify the buyers in writing either that 1. Sellers agree to remedy the deficiencies as requested by buyers, in which case this purchase agreement, as so modified, shall be binding on all parties. Or 2. Sellers do not agree to the remedy request in whole or in part and offer a counter-proposal to buyers. Upon receipt of said counter-proposal from sellers, the buyer shall have 5 days in which to accept the seller's counter-proposal by signing it, or to notify the sellers in writing that such steps are not acceptable, in which case either sellers or buyers may declare this offer null and void, and any earnest money shall be returned to buyers. In the absence of written notice of any deficiency from buyers, or if buyers fail to respond to the seller's counterproposal within the time specified herein, this provision shall be deemed waived by parties, and this purchase agreement shall remain in full force and effect. If the sellers fail to respond to the buyer's remedy request within the time specified herein, buyers may declare the offer null and void, and all earnest money shall be returned. So it's really offering protection for you and the buyer, so that everyone understands what we're working with here. Okay, and here is a checkbox in place for your initial. Buyers acknowledge they have been advised of their right of property inspection and have declined to make said inspection. You will not initial that because we do have to have the property inspection to work with Camden Savings and Loan. Okay, the buyers must choose one of the following alternatives relative to the presence of radon in the home. And of course, the radon inspection is optional. It usually runs around $85. I cannot advise you one way or the other. That is totally up to you to decide whether or not you want to have a radon inspection done. You do not. Okay. But you do have the right to have that done. But you do not want to have it done. Okay. Buyers acknowledge they have been advised of their right to conduct a radon test, and you have declined said test. So when we get ready to initial everything, I need you to initial that. Septic system, you do not have a septic system. You are on city water and sewer, so we don't need to worry about that. It's not applicable. Okay, Section E. The buyer shall be permitted access to the property prior to possession or closing, whichever is sooner, in order to determine that there have been no changes in the condition of the property, except those mutually agreed upon, and that it is ready for buyer's possession. At the time of closing or possession, whichever occurs sooner, buyer will accept property in its present condition without further warranties or guarantees by sellers or broker concerning the condition of the property. This, however, shall not relieve the sellers of any liability for any conditions that are defined as latent defects or any express written warranties contained in the purchase agreement or other written agreement between the parties. Nor shall this paragraph relieve the sellers of any liability for any implied warranty applicable under North Carolina law. And like I said, we are asking for a home warranty to be paid for by the seller. And that, like I said, is about $485. Okay. The inspection of any part of the property not covered in 9B, Section 1, or the remedy of any condition not addressed in 9B, Section 1, including but not limited to cosmetic conditions that the buyers require, shall be addressed in paragraph 27 of this purchase agreement. Okay, wood destroying insect inspection. That is your termite inspection, and that is required by Camden Savings and Loan. And we're going to use the same time and date. We're going to say by 12 p.m. on May 17th, 2017. And the termite inspection is typically around $175. And yes, we will. When it's time to do the termite inspections and the home inspection, I will have you write out those checks separately, directly to the companies doing those inspections. So I don't need that today. First, we want to wait and see how the buyer or the seller responds to this. So we're going to say for the wood destroying insect inspection, by 12 p.m. on May 17th, 2017, buyers may, at buyer's expense, have the property inspected for termites or other wood-destroying insects by a licensed pet inspector. If active infestation or damage due to prior infestation is discovered, sellers shall have the option of either having the property treated for infestation by a licensed pest exterminator and having any damage repaired to the buyer's satisfaction, or declaring this purchase agreement void. This provision shall not apply to fences, trees, shrubs, or outbuildings other than garages. So that would also apply to the garage, not just the house itself. So if they found termites, like anywhere under the garage, or if it affected the garage directly, it would be included in this section. Buyers may accept the property in its existing condition without such treatment or repairs. So even if they find termites, if for some reason you don't expect the seller to do anything about it, we can just leave it like it is. Okay, this doesn't apply to you. It says if buyers are obtaining VA financing, then the cost of the termite inspection shall be borne by the sellers. That's you're not doing a VA loan. Okay. And you do not have the right. You cannot decline since you're working with Camden. You have to have it done. And then we have insurance. Okay, you will have to purchase homeowner's insurance before closing, and you will have to provide proof of that insurance to Camden Savings and Loan. And I would recommend With the insurance, I would recommend talking to perhaps the people that you have car insurance with. A lot of times you can get a discount. You can get a better rate on your homeowner's insurance if you bundle it with your car insurance. That's what most people do. That's what I do. And it can save you quite a bit of money to do it that way. But of course, it doesn't hurt to shop around. You might find a better deal somewhere else. So we're going to read this. Okay, sellers shall bear the risk of loss or damage to the property prior to closing or possession. But you will have to have the insurance if you're going with Camden. They do require that. Sellers agree to maintain existing insurance, and buyers may purchase additional insurance. So the seller will maintain the insurance up until the closing date, and then it's your responsibility to take it over from there. In the event of substantial damage or destruction prior to closing, this purchase agreement shall be null and void unless otherwise agreed by the parties. So say a tornado hits it on May 30th. It's up to you to decide whether or not you want to do anything. You can still buy it, or you can change your mind. The property shall be deemed substantially damaged or destroyed if it cannot be restored to its present condition on or before the closing date, provided, however, buyers shall have the option to complete the closing and receive insurance proceeds regardless of the extent of damage. Okay, and then section 12, we have use of purchase price. At time of settlement, funds of the purchase price may be used to pay taxes and other liens and to acquire outstanding interests, if any, of others. Abstract and title. Sellers at their expense shall promptly obtain an abstract of title to the real estate continued through the date of acceptance of this offer and deliver it to buyers for examination. It shall show merchantable title in seller's name in conformity with his acceptance of this offer. In conformity with this purchase agreement. North Carolina law and title standards of the North Carolina State Bar Association. The abstract shall become the property of the buyers when the purchase price is paid in full. Sellers shall pay the costs of any additional abstracting and title work due to any action or omission of sellers, including transfers by or the death of sellers or their assignees. If at the time of closing there remain unresolved title objections, allowing a reasonable time for the corrections of said objections, provided, however, that the commercial mortgage lender of the buyers will not make the mortgage funds available with such escrow. The provisions for escrow for title defects shall not be applicable. Joint tenancy in proceeds and in real estate. If sellers, immediately preceding acceptance of the offer, hold title to the real estate in joint tenancy with full right of survivorship, and the joint tenancy is not later destroyed by operation of law or by acts of the sellers, then the proceeds of this sale and continuing or recaptured rights of sellers in the real estate shall belong to sellers as joint tenants, with full price due sellers under the contract to the surviving seller, and to accept a deed from the surviving seller consistent with paragraph 7. I know it's all kind of boring, but it's totally necessary, and I am required to make sure we go over these things. Jointer by seller's spouse. That's not going to apply since you are not married. Section 16, remedies of the parties. If buyers fail to timely perform this contract, sellers may forfeit it as provided in the North Carolina Code, and all payments shall be forfeited, or at seller's option, upon 30 days written notice of intention to accelerate the payment of the entire balance because of such failure, during which 30 days such failure is not corrected. Sellers may declare the entire balance immediately due and payable. Thereafter, this contract may be foreclosed in equity, and the court may appoint a receiver. If sellers fail to timely perform this contract, buyers have the right to have all payments made returned to them. Buyers and sellers also are entitled to utilize any and all remedies or actions at law or in equity available to them, and shall be entitled to obtain judgment for costs and attorney fees as permitted by law. In the event the buyers fail to perform their obligations hereunder, and the sellers successfully forfeit any payments made under this contract, upon receipt by sellers, the sellers shall pay broker 1/2 of the forfeited payment. said 1/2 not to exceed the total commission due to the broker. In the event the sellers fail to perform seller's obligations under this contract when required to do so, seller shall pay to broker the broker's commission in the amount set forth in the seller's listing agreement with the seller's broker. Okay, and then section 17, we have a statement as to liens. If buyers intend to assume or take subject to a lien on the real estate, sellers shall furnish buyers with a written statement prior to closing from the holder of such lien, showing the correct balance due. And that does not apply here. Approval of court. If the sale of the real estate is subject to court approval, the fiduciary shall promptly submit this contract for such approval. And that doesn't apply here either. Contract binding on successors in interest. This contract shall apply to and bind the successors in interest of the parties. Construction. Words and phrases shall be construed as in the singular or plural number and as masculine, feminine, or neutral or neuter gender, according to context. Survey and square footage representation. The buyers may, within, I'm going to give them 14 days. Within 14 days of acceptance of offer, have the property surveyed at their expense. And that is up to you. That is something that you can decide, and you'll have 2 weeks after, assuming the offer is accepted, you'll have 2 weeks to have a survey done if you're interested, and you would have to pay for that. If the survey, certified by a registered land surveyor, shows any encroachment on said property, or if any improvements located on the subject property encroach on lands of others, such encroachment shall be treated as a title defect. Assuming a representation for square footage has been made, buyers understand and agree that said representation is only an approximation of the exact number of square feet the property contains. The buyers have the right to obtain their own measurement of square footage. And then we have agency disclosure in section 22. The listing and selling agents, brokers, are agents of the parties hereto as outlined below, and their fiduciary duties of loyalty and faithfulness are owed to the party they represent. However, they must treat the other party with honesty and fairness. Okay. Now here we have the last part. Now I filled this in from the information that I received from the seller's agent. The seller in this transaction is represented by Smith & Jones, which is the brokerage company, and their email, fax number, and then there was nothing else, so I left that blank. Residential property seller disclosure statement. Okay. We'll go over that. The buyers acknowledge receipt of the residential property seller disclosure statement prior to executing this purchase agreement. And we're not ready to do that yet. Okay, and right now we are not going to worry about some of this stuff because I'm still waiting for some documents from the seller's agent. And you said you could get together. You said you could get together with me again Thursday. Okay, wonderful. See, I'm thinking about Thursday. We should have the things that we need. And at that time, I will have you initial and sign these forms where needed. Now, the reason I don't want to do that yet is because I got this property disclosure statement and it's not complete. And he also did not sign it. So I am not comfortable with you signing off on everything until we have everything completed by the seller. And I'll show you what I do have. Okay. The seller's John Jones. And again, the property that we're dealing with is 127 North Main Street in Camden. He purchased this property January 27th, 2004. The house itself was built in 1997. Okay. Every seller is obligated to disclose to a buyer all known facts that materially and or adversely affect the value of the property being sold. This disclosure statement is intended to assist the seller in complying with disclosure requirements and to assist buyer in evaluating the property being considered. The listing broker, the selling broker, and their respective salespersons will also rely upon this information when they evaluate, market, and present sellers' property to prospective buyers. And then there's a notice to you, the buyer. This is a disclosure of seller's knowledge of the condition of the property as of the date signed by the seller, in which he did not sign it, so I'm going to have to talk to his agent about that. And is not a substitute for any inspections that buyer may wish to obtain. So you really shouldn't base your opinion just on what he says here. You'd be surprised what gets left out. So, even if Camden Savings and Loan did not require a home inspection, I would always advise people to have one done. You'd be surprised what comes up. It is not a warranty of any kind by seller, or a warranty or representation by the listing broker, the selling broker, or their salespersons. If this property is unimproved, complete sections 15 to 20 only. But that doesn't apply here. Okay. In section 1, we have the occupancy. Does seller currently occupy this property? Yes, he does. So that doesn't apply. Is this property tenant occupied? No. So we skip down to here. Structural items. Name of contractor or builder who built the home if known. And he actually did know. A lot of times this is blank. It was built by Thompson Builders in 1997. Are you aware of any past or present movement, shifting, deterioration, structural damage, or other problems with walls or foundation? He checked no. Are you aware of any past or present cracks or flaws in the walls, foundation, or other parts of the property? No. Are you aware of any past or present water leakage or intrusion in the property? No. Are you aware of any past or present problems with driveways, walkways, patios, or retaining walls? No. Have there been any repairs or other efforts to control the cause or effect of any problem described above? No. Has there ever been a fire in the property? No. Are you aware of any problems with the fireplace? No. And since he answered no to everything, he doesn't have to explain anything here. Section 3 deals with additions and remodeling. Have you made any additions, structural changes, or other alterations to the property? No. And then you skip down to here. Did the previous owners make any additions, structural changes, or other alterations to the property that you're aware of? And he put unknown, so he doesn't know. And again, this is where both the buyer and the seller are going to initial. He did not initial, so I'm not going to have you do anything right there. Now, this goes over just some general information. He has owned the property from January 27, 2004 to present. Does any other party have an ownership or spousal interest in the property? No. Is the property a condominium or a freehold property that includes an interest in a common elements condominium? No. Is the property subject to first right of refusal, option, lease, rental agreement, or other listing? No. Are there any encroachments, registered easements, or rights of way? No. Is there a plan of survey? It's not applicable. Are there any disputes concerning the boundaries of the property? No. Are you aware of any non-compliance with zoning regulations? No. Are you aware of any pending development, projects, or rezoning application in the neighborhood? No. Are there any public projects planned for the neighborhood? No. Are there any restrictive covenants that run with the land? No. Are there any drainage restrictions? No. Are there any local levels or unusual taxes being charged at the present time or contemplated? No. Have you received any notice, claim, work order, or deficiency notice affecting the property from any person or any public body? No. Is the property connected to municipal water? Yes, it is. And municipal sewer? Yes. Are there any current or pending heritage restrictions for the property? No. So, I mean, all this looks really good. This is, wonderful. Sometimes it seems to me that a lot of sellers are kind of cagey about the way they want to answer some of these things. They'll either, quote unquote, accidentally leave them blank, or their answer is kind of vague, or they'll put in lots of NAs or unknown, and those make me very uncomfortable. Okay, now this, I just want to go over a little bit here with the seller's information. These are some things that are going to be included. I know you had a few questions about some of the things in the kitchen. I got this from the seller's agent, so I just wanted to go over this, and we can look at it in more detail when you come back Thursday. Okay, and these things are going to be left in the home. I know you wondered about some stuff. It's going to leave the range, the oven, microwave, dishwasher, the garbage disposal, which is down there in the sink, washer, dryer hookups. He did not put anything about the washer and dryer, so I don't think they're going to stay. They usually don't. Rain gutters, fire alarm, central heating and air, public sewer system, patio, gazebo. I know, I love that gazebo too. It is so neat. Attached garage, electric water heater, city water supply, window screens, and water conserving plumbing fixtures. And he says here that he has exhaust fans in the bathrooms and the kitchen. The roof type is asphalt shingles and was installed about 2 years ago. And he initialed it, but he actually did not fill in some stuff up here, so like he didn't check this. He said earlier that he is still living in the home, but he didn't check the box saying that he is. So again, I'm going to tell his agent that you will not be signing these until we received the complete signed copies from the seller. Okay, now this is the disclosure of information on lead-based paint and or lead-based paint hazards. Now this house was built in 1997, so lead-based paint is really not a concern, but we still give these out to people. And the lead warning statement is included. Housing built before 1978 may contain lead-based paint. Lead from paint, paint chips, and dust can pose health hazards if not managed properly. Lead exposure is especially harmful to young children and pregnant women. Before renting pre-1978 housing or buying, sellers must disclose the presence of known lead-based paint and or lead-based paint hazards in the dwelling. Buyers must also receive a federally approved pamphlet on lead poisoning prevention. And I have that in your packet, which I'm going to give to you before you leave. And here we have the seller's disclosure. The seller has no knowledge of lead-based paint and or lead-based paint hazards in the housing, which I would be surprised if there were any lead issues, with the paint, because the house was built, like I said, in 1997, and by then we had done away with lead-based paint. The seller has no reports or records pertaining to lead-based paint and or lead-based paint hazards in the housing. That's good. And then you can acknowledge this, but again, you don't need to fill it out now. Buyer's acknowledgement, you just would initial that the buyer has received copies of all information listed above, and that will be in your packet. Buyer has received the pamphlet, Protect Your Family from Lead in Your Home. And then I would acknowledge that later. And then you have the certification of accuracy. The following parties have reviewed the information above and certified to the best of their knowledge that the information they have provided is true and accurate. And see, again, I'm surprised that his agent let him do this. He filled it, he checked these boxes, but again, he didn't sign. He didn't actually sign the form. So I'm kind of surprised that the agent would send me these things. She emailed them to me, and I'm really surprised that she didn't catch all this. She must not have looked at them. So that is all that we need to go over right now. When we're done here, I'm going to give the seller's agent a call with our offer and just make a verbal. I'm going to do just a quick verbal explanation of what we want to propose, and to also let her know that we need to have some gaps filled in on these documents before you sign anything. And if at all possible, I'm going to get all this done before you come back on Thursday. So, like I said, we're not going to sign anything right now because I would never want to sign something that's not complete, and I would not expect you to do that either. So, do you have any questions for me at this point? I will. I will get a receipt when I take the earnest money check to the attorney's office in the morning. I will get them to write out a receipt, and I can either email that to you or I can give it to you on Thursday. It's up to you. Okay. I will hang on to it, and I will get it to you on Thursday. Okay. Well, I've got my fingers crossed. With this being a very motivated seller, I think it's going to go well. I don't see them coming back with an unreasonable counteroffer, if they come back with a counteroffer at all. Sometimes they don't. But I will let you know if I hear anything today. I will text you and I will let you know what I find out. And between now and Thursday, I will work on getting the completed forms from the seller, so that when you come back on Thursday, we can get everything initialed and signed and squared away, and then it will be all fit and ready to go. Okay? Great. Well, thank you so much for coming by, and I look forward to talking to you again soon.